Hello and welcome to Crane Talk, a podcast that covers all things cranes, rigging, and heavy iron. My name is Isaac Smith, and today I'm joined by three experts in the industry, Ron Thompson, Gene Greiner, and a special guest. Gentlemen, who would like to take point on introducing today's guest?
I'll be happy to, Sir Isaac. We're privileged to have Michael Rubin. He is a shareholder at Ogletree and Deacons. His focus is exclusively on handling OSHA matters nationwide, and his forte is the crane and rigging industry. He's handled matters in 40 states. He's a speaker at AGC, at SCNRA. He's also a guest lecturer at Columbia University Construction Management Master's Program. It's an awesome resume. And when Walter White and Jesse Pinkman got in trouble, they called Better Call Saul. When our crane clients have an issue with OSHA, they better call Michael Rubin. Michael, how you doing, man?
Good. Gene, how are you? Thank you for that introduction.
Good to see you.
Well, hey, also, Michael, you attended in triple CO certification programs. And do you have your crane operator's license?
I think for the safety of all people in the country, it is expired. But I did do that. And that was when I was first getting involved in the crane industry. I really liked the people, liked the issues, liked everything about it, and realized the one problem is I don't know much about cranes, so I better learn that pretty quickly. So the NCCCO, now I think it's just CCO, but I took classes in North Carolina, took the tests, and really did help me at least issue spot and understand the issues that crane operators face, as much as I can being in an office a lot of the time.
I think you're one of the few attorneys that actually emphasize specifically with OSHA cases with the crane and rigging industry. And I've heard you speak at SCNRA and the Texas Crane Association, and you capture a lot of eyeballs. And I saw on LinkedIn where you have over 31,000 followers. That's more than Trump. I mean, that's
Don't get me in trouble on any list, Gene.
Yeah. So, we're just privileged to have you. And I think our first question, Michael, under the new administration, we hear OSHA under the Trump administration, they have reduced enforcement and inspections, lower inspector staffing. There's an emphasis on voluntary compliance, and it's a more business-friendly approach. Is that true or false?
From what we've seen, I would say false. Maybe to a slight extent, but not such a dramatic change that it's really fundamentally shifted how OSHA enforcement works. We're still getting calls. OSHA inspectors are still as aggressive as ever. We haven't noticed a change. Let's put it that way.
Okay. So you get a call on a Saturday evening. It's from a client. It's not usually, hey, Ron, how's the family doing? It's something that happened in a remote part of the country where there's been a serious accident. And the first question they ask is, what do we do? So we usually call the First Defense Counsel. We usually call maybe a forensic causation accident engineer. When should we be calling you?
Well, I think it depends on the severity of the matter. I mean, all incidents really are not created equally. I mean, if you have a fatality or multiple employees injured, right away, I mean, just thinking from exposure on the liability front and then regulatory front as well, maybe even criminally. Those are really big matters, right? So usually we get involved pretty quickly. If it's a fatality, we're involved right away. And that is because what people don't realize also is if OSHA shows up, they're doing their inspection, they're getting facts and evidence. Those facts and evidence, that can find its way into a related wrongful death or liability action. And usually OSHA comes first. I mean, OSHA arrives unannounced. They might show up the same day as the incident. So when first responders show up, they're telling OSHA, okay? And then OSHA's immediately showing up unannounced. Right that same day as that incident, you can have an OSHA inspector interviewing management who are sort of reeling from this loss. And management, they might not be prepared. They might not, mentally be ready to start talking because there could be a traumatic incident. And everything your managers say during that initial day or initial days after the incident, the OSHA inspector is writing down, it's going in the OSHA file, and that file can be obtained literally by anyone in the entire world by submitting a FOIA request, Freedom of Information Act request. And then on the heels of this, maybe months, years later, there could be a wrongful death action. There could be a just, regular personal injury or property damage suit. And the plaintiffs, plaintiffs are smart. They're going to go and search for evidence. So they submit one of these FOIA requests, and you have in those documents, managers may be making admissions. Maybe they're inaccurate. They think they're being honest, but they just really don't have all the facts. So they're just, drawing some inferences that are incorrect. That can be very damaging and pollute a liability action. So having counsel in very soon, I would say in real serious matters where the exposures are great, it's a lot more controlled. It follows better procedural steps. Everyone knows why things are happening, and it's less loose. So that's my personal view. Other of my colleagues might say we should be involved from the beginning on everything. That's a judgment call on how employers manage their risk. But certainly, really bad matters, attorneys have to get in right away.
Aside from the attorney involvement, is there any type of difference of how the employer should respond based on the severity of the accident? Like, do you give advice of, okay, if there's a fatality, these are the absolute musts. This has to happen versus, someone is hurt in a less severe manner. Is there any type of difference between that, or is it pretty well static?
We pretty much have a playbook. I mean, OSHA defense attorneys that are doing 100% of their practice is OSHA. There are sort of guidelines or procedural steps that, for example, I would recommend or immediately think of largely in any OSHA matter. But you don't want to be married just to, these like hard and fast rules. In every single case, you're not going to give management interviews the first day OSHA's on site. Well, sometimes there might be a benefit of doing that, probably not very often, but it's really case by case basis. But by and large, the way we think of defending OSHA matters really applies to all OSHA matters.
Do you find, Michael, the OSHA inspectors and even their counsel, do they truly understand the crane and rigging business?
I'm sure they're out there, but the short answer is no. I mean, we had a matter in North Carolina where we had a settlement conference with the hearing officer. This was a fatality matter. It was getting very close to a hearing, which is basically the equivalent of a trial in an OSHA matter. And opposing counsel really, after I was putting forth our client's position, and I was talking about ASME B30.5, talking about the limited exposure and responsibility of crane rental companies and operators, she said point blank, "Wow, it looks like you really understand cranes. You're going to have to explain this stuff to me." I mean, that is the attorney representing the government enforcing a citation in a fatality matter. And we actually went on to win. We filed a motion for summary judgment supported by expert testimony, and we won that matter. So cranes, it's not easy in some ways. The limited responsibility of crane rental companies, it's sort of counterintuitive. You think there's this bad accident, you think, well, the operator's at fault, but might be in the blind, taking commands from a signal person who's not an employee of the crane rental company, got riggers. Again, a crane operator is just one person. Let's say it's a rental with a crane and an operator. That operator can't be every single place. And actually, under the law, we argue, and we think this is 100% accurate, crane operators have limited responsibility on a crane site. They have an exceptionally important job, but at the same time, they're not responsible for the rigging. They're not responsible for the signals. And again, this is generally stating it. There might be exceptions, but OSHA doesn't know that. It's just very easy. And we understand, even on the liability side, crane companies are repeatedly getting unfairly blamed. Yeah, sometimes it's warranted, right? I mean, you analyze a case, each case separately, but this is actually a fundamental issue in the entire industry as I see it.
Well, it's their own playbook too, right? So how often are when you're defending someone or if you're involved in a negotiation with OSHA or a defense, like the inspector or the OSHA agents, like how young are these people? Because I mean, the rule book you're talking about is their rule book, right? So are you seeing experience in this field or is
so this is before Doge and the issue with many workers with the Department of Labor, including inspectors, retiring and leaving. Even before that, I would say a couple years before, OSHA had mentioned that about 20% of inspectors, and it might even be more, but at least 20% had been on the job only 1 or 2 years. So imagine there's a 1 in 5 chance you're going to get someone who really doesn't have much experience. And considering that OSHA inspectors have to cover almost an infinite number of different scenarios and industries, how can you really build up the subject matter expertise that quickly?
So we have data, and you actually read my notes, Michael. We have data crunched that shows the approximate cause of an accident on a job site is about 19% the responsibility of a crane operator sitting in a cab of a crane. That leaves 81% to participate with other responsible parties. And when ASME B30 put out their responsibilities on job sites, I think there's about 9 or 10 different entities that could participate. So when you have to tell that to a 2-year tenured OSHA inspector, I can see where the crane operators need Michael Rubin to filter through this stuff.
Ron, I mean, it is true that OSHA doesn't really understand this. And I don't want, let's say someone from OSHA is listening, they might say, I beg to differ. I understand this very well. And that's true. There are, OSHA does understand some aspects, but there's just a great variation among the inspectors as to their knowledge base on cranes, because ASME B30.5 it's not an OSHA standard. So they start hearing other stuff. It's like, well, I'm just going to stick to the standards. So we actually have a case right now. We're drafting a position letter on behalf of a crane company. We have an expert, and part of that process is to show that ASME B30.5 is relevant, and it has been considered by courts, not just courts in OSHA matters, but also federal and state courts, to say this is, you can't ignore what this says. You really have to take it into consideration. So unfortunately, a lot of crane matters, including and especially OSHA matters, it's really an educational process where, just like I was learning cranes at one point, now you're trying to educate OSHA, and oftentimes they agree. I mean, we've had citations withdrawn. Unfortunately, though, oftentimes you do have to get an expert, because if a company just says, no, OSHA, you've got this wrong, they've heard companies say that before. And there is this bit of questioning the credibility, because obviously a company saying that, or even our office saying that, yeah, we're biased. We want the best possible result. But then when you have an expert or anyone else involved, even a consultant, saying that it's true, then that really forces OSHA to consider, do we need our own expert? And actually, can we get an expert that's going to actually disagree with this? Because again, if you go to trial and you've got an expert giving testimony saying there is no violation because of these different factors, well, OSHA's got to their attorneys have to cross-examine that expert, or they need their own expert. So it it's sort of, they say the best defense is a good offense. You're going on the offensive, not holding any defenses in your back pocket. And that's generally what we see crane companies need to do to really be successful in these matters.
We also have to educate our insurance partners and sometimes defense counsel on the multi-employer doctrine, borrowed servant,
underwriters,
defense
counsel, claims
because
people.
they don't understand it either, Michael.
Yep,
so
it's true.
we're there. We don't know it all, but we are familiar with the standards in B30.5, and we educate our partners about, you got to look at different defenses here, not just pull out the ATM machine and start paying. I have a question though. OSHA fines are public record. And say you're successful in getting a fine reduced or removed. Is that updated on the OSHA website where you can access the fines of clients? I mean, are they up to date on this stuff? Or
Ron, that's a great question. They do update the records so that if you're doing, for example, an establishment search, OSHA will update that. Sometimes there are some failures in execution, meaning OSHA doesn't get around to it or it gets missed. So we have had clients write and say, hey, what's up? We're bidding work and it still shows we have 4 serious violations. We got 2 withdrawn and the other 2 reclassified to OTS other than serious. You need to, can you please help us get this figured out? And invariably we write to the area director and they get it updated. And we've actually had, various responses, but we've had apologies from area directors saying, hey, I'm really sorry about that. We'll get this updated right away, and they get it done.
But if you don't inquire, do they update it?
They do. I would say 90% of the time, maybe 95% of the time, it is updated without you having to ask. But we know, and I don't have all the data, but we know sometimes either the office forgets or gets missed because clients write and say, hey, we still have this stigma here. We won this matter. And, prospective clients are asking for information about it.
So another question. Once a fine is assessed and maybe it's not negotiated, there's also a lot of additional cost involved with the fine because it becomes public record and everybody can see it, including our clients' customers. Insurance companies can see it. So when you do have a fine, I mean, that's just part of it, Michael. There's this potential loss of revenue from not getting jobs, reputational harm, increased insurance costs. So it's a big deal when it becomes public record and nothing is done. Say it's reduced or you're successful in getting it removed, but just the fine itself there's all this additional. It's important to address these and maybe get them reduced or removed.
Yeah, that's a great point. Many of the companies that call us, they realize this is going to negatively impact us way beyond this monetary penalty. So, for example, it could be loss of future work, like you said, reputation, even morale. I mean, if you contest an OSHA citation, you have to post that letter of contest in the office, right? And there are multiple times during an OSHA procedure, the OSHA proceedings where you have to post things like the letter of abatement, in the office talking about it. If a company gets cited by OSHA and they're going out of business the next day and it's a $10,000 fine and they can pay $5,000 and be done with it, okay, who could argue against that? I mean, just be done with it because there's no future risk. But if you're not going out of business and you do want to have a long, profitable history of your company, unless your clients and prospects aren't looking at your history, you really are incentivized to do your best to get rid of it.
So aside from morale, reduced revenue due to losing work and obviously the cost of the fine itself, what about the risk of criminal implication? where does that enter into the conversation through these negotiations and proceedings?
Yeah, so any fatality, let's just say New York City, okay, because I handle a fair number of matters there. Any fatality matter in New York City, OSHA showing up, most likely the New York City Department of Buildings is showing up, and then also the New York City Department of Investigations is showing up. The DOI, it's kind of scary because they have criminal referral authority. Sometimes you might even have, I've heard, I haven't witnessed it firsthand, but an assistant district attorney could show up on the site. So if you have a fatality and it's connected to a willful violation, you can go to jail. And there are examples of this: trench collapses, fall protection, the big obvious hazards where employees prior to an incident were basically pleading to their employers to provide protection and they don't, and then someone gets killed. There's a very, very good chance you are actually going to jail for that. You're going to prison. You really don't want criminal exposure to be a reason to keep your workers safe. But the reality is, I've got well over a dozen different fatality matters handling right now. Okay. Many of those calls came in because someone said, wow, we had a worker die. How far can this go? And we have to tell clients, technically, yes, you could be criminal exposure here. Usually, thankfully, our clients, all the facts and circumstances have been, something was just missed. It was unforeseeable. It was a lack of communication, lack of situational awareness. It's not something that was truly criminal, but that's scary. As an owner of a company, you have to make sure you're protecting your workers.
Does OSHA every year increase their fines due to, say, inflation measures they use?
They do. Now, just so the audience knows, I don't know any of the questions being asked, and I don't want to say I'm unprepared. I'm showing up with my general knowledge. This is something I can't figure out right now. OSHA has not increased their penalties for 2026. Every year they have. I did a LinkedIn post saying, did OSHA forget to raise its penalties in 2026? And went back the last 5 years showing it's always in January. It's around the middle of January when the penalties are increased. And I wonder, at some point, someone's going to text me and say, hey, Mike, shut up. We get it. It doesn't make sense why they didn't increase the penalties, but it's not your job to be a gatekeeper or, enforcement officer of an increase in penalties. No one wants that, but I can't understand it. And maybe finally, maybe by the time this podcast comes out, OSHA will have increased them. But so far, no explanation. But yes, every single year they increase their penalties. Just to give a bit of a history lesson about these penalties, for about 25 years, I believe it was 1990 to about 2015 or 2016, there were no penalty increases. And then in or around 2016, it all changed. There was a catch-up provision, penalties increased. I don't remember the percentages, but it was something like 80%. And then, Ron, what you mentioned, every single year, some calculation, I think it's some, inflation index, the penalties increase. So we'll see what happens this year.
Well, I don't know, I might have listened to one of your seminars, but didn't OSHA change the way they used to? If you had five people on a job site, each create an infraction, they would kind of group it up.
Right.
And then they changed it where they could actually file 5 different citations. Is that something they just changed?
Yeah, it was. So I think it was either 2023 or 2024, but it's relatively new. OSHA changed its policy. What you described is instance by instance violations. So in the past, there were limited instances, no pun intended, where you could actually do instance by instance and fine, let's say, issue 5 fines related to 5 different training infractions, let's say, right? Now, OSHA can do these instance by instance. So if you have 5 workers who are untrained on a job site, they can say, well, in the past, it would just be 1 violation. Guess what? There's 5 workers. Now it's a multiplier of 5. And we actually had that, I think it might have been a couple years ago, as a fatality matter. It wasn't even our employee. So this was a multi-employer site. They cited our client as a controlling employer 5 different training violations by virtue of the fact that the subcontractors workers, these 5 guys who were on site, including the decedent, allegedly weren't trained. I will say we got all 5 of those vacated. OSHA voluntarily withdrew those 5. And I think this ties into the penalty increases. OSHA probably wishes its penalties were much higher to have a much bigger impact on compliance or a deterrent effect. With the penalties every year increasing, it's really a minimum amount or minimal amount. This instance by instance all of a sudden can dramatically change the playing field, because you might have a 5% increase year to year, but now it's like, well, forget the 5%. We've got a multiplier. If there were 5 employees who weren't trained, now we can just give 5 different violations, and it's much, much more, and that's a much bigger impact. So that's a real thing that happens.
I've heard you speak about the Fourth Amendment, and when our clients have the impression that they have to answer all of OSHA's questions, and it's interesting your take by asserting the Fourth Amendment. Can you give us a little bit of detail of what the Fourth Amendment is and why they can't assert it, and should they assert it with an attorney present?
So this is a great question. Before I get into the specific answer, employers should recognize they have incredible rights during an OSHA inspection. And although the government can be imposing, OSHA actually doesn't have a lot of power. I mean, OSHA does have the ultimate power to cite employers. So we recognize that, employers recognize that, and I think that's why when OSHA shows up, employers are nervous, and it makes good sense, right? No one wants a government coming in to inspect them. But the Fourth Amendment does apply to OSHA inspections. The Fourth Amendment protects employers from unreasonable searches and seizures. And a search basically is an OSHA inspection. So when OSHA shows up, basically, and just generally stating the rule, OSHA needs one of 2 things, either a search warrant or they need you to consent to the inspection. So when OSHA shows up, if you know this, you can really limit it, or at least control the inspection, because you might say, for example, I know you don't have a warrant, we are inclined to consent, but before we do, we need to know exactly what you plan to do, and then we'll consent to that if we have a mutual understanding. Because OSHA inspectors really never show up with a warrant. They might only show up with a warrant if you've already denied consent once. So they're not gonna go back again and say, hey, this time will you let us in? They're gonna get a warrant and show up and have, access to the work site. Federal OSHA and state plan states, they do it a little differently. My understanding of how Cal OSHA does it, they might, for example, ask for, express consent, like, do you consent? Federal OSHA, there's something, it's really be tough for employers. It's called implied consent. So if OSHA shows up and the inspector does not have a warrant, does an opening conference, says why he or she is there, and then starts walking the site and you start following, you impliedly consented under the Fourth Amendment because you didn't say, I don't consent to this, stop. So if you don't know that right, you certainly won't be able to raise it. When I bring this up, oftentimes companies think, I think they think, well, who's going to deny consent to OSHA? Because in that instance, you're just going to piss them off. They're going to go get a warrant as soon as possible, and then they're going to rake you over the coals.
Yeah.
I don't know that I've ever recommended a company say, go get a warrant. I don't think that's ever happened. What we might say is, we will consent, but someone needs to get to the site. We're willing to consent in 2 hours. Sorry, I wish we could consent right now, but this person getting to the site is indispensable to the process, and this person is just too important. So basically, you can use the right to consent or not as leverage, and have some control over that inspection.
And they don't view that as adversarial. They view that as just a normal way to do business.
Gene, it's adversarial if the client asserts it. If Michael asserts it, it's not adversarial.
Well,
right.
This is really unfortunate, Ron, what you mentioned. Well, Gene, same thing though. Both points well taken. Sometimes it's how you say it too. If OSHA shows up and say, we don't consent, and you're not, conversing, there's no communication, each is going to immediately entrench into different sides. But we found, believe it or not, at least when we're saying it, OSHA inspectors know that we understand the process. And while we might assert clients' rights, and that could be annoying in certain instances, we do know the limits of our clients' rights, and we're not going to overstep what's proper. So they know, all right, they might insist on, dotting the I's, crossing the T's, but they're not going to take it too far. At least our firm won't. Ogletree has a great reputation with OSHA, I would say, across the entire country. But we have seen when employers assert their rights on their own, all of a sudden, and again, I have examples of this. So I know, let's say OSHA's listening, they're going to say that's outrageous. We're always acknowledge employers asserting their rights. That's true. Might be true in most cases, but calls we've received, we noticed a big difference when the employer tries to assert their rights, and an inspector might act like the employer just slapped the inspector in the face, and they get, really bent out of shape about it. And then when we get involved, it's like, okay, well, it's the attorney saying it, so maybe we should give some more deference. It's a lawyer. And again, I don't think that's prevalent. Is not something, because again, I don't want to give a bad impression that OSHA treats employers poorly and treats attorneys better. Sometimes it's the inverse, right? But we have seen that happen where we get involved and our clients even on the phone, and they're like, Mike, you have to understand, the inspector completely changed his tone once you got on the phone. And it's because they know we're armed with their rights and we're not afraid to raise them.
Is a general duty clause, is that used very often?
Again, I didn't ask Ron or Gene to ask any questions. These are questions I love. So nice job, guys. General duty clause is raised all the time. The general duty clause, if you read it, it's in the OSHA Act of 1970. It seems like a simple enough clause, but when you really start stripping away the outer layers, it is really in depth. And I will say it's not easy for OSHA to win on a general duty clause case. I'll refrain the second from getting into all the elements, but there's a lot of meat on the bone of a general duty clause case and many defenses. I love litigating general duty clause cases. We took one to trial last year in 2025. Another one, I think it might have been 2023 or even 2022. But those issues, oftentimes there's expert testimony. What the industry recognizes as a hazard can be relevant in those matters. So sometimes OSHA says, the employer, okay, you didn't recognize this as a hazard on your site, but guess what? Your industry recognizes it as a hazard. So you lose. It's a really, I would never say fun, but we enjoy litigating those matters because there's a lot of really interesting issues that can, cut either way on those. And OSHA absolutely still alleges general duty clause.
That's why I brought it up. How many depositions have you taken in your career?
Well, it's definitely hundreds. I don't know if it's thousands. I litigated in New York City for a solid 10 years right out of law school. So imagine graduating law school, being so excited, you're a lawyer, you pass the bar, and then your reward is going to these courthouses in the Bronx, Brooklyn, Manhattan with these absolute animal plaintiffs attorneys. And I'm not going to say, well, I'm just generalizing. No, we were dealing with some really aggressive plaintiffs' attorneys. I mean, they call New York City a judicial hellhole for a reason, and there's other judicial hellholes across the country. But tons of depositions, and this was representing primarily construction companies in personal injury matters. You might have 5 depositions a case. I mean, you're at least going to have the plaintiff, then you have the defendant, at least one representative per defendant. But then when it's construction, I mean, it's multi-employer work site, so you've got multiple defendants. So I would say, I don't know, probably at least 500 depositions. I mean, that might be a conservative number, but I mean, you might have 20 in a month. I mean, it was a lot of depositions.
So I'm going to ask you a personal question. When you were a law student at Seton Hall, did you look around and say, when I grow up, I'm going to go fight OSHA cases? How did you get involved with this?
Yeah. So the answer is, I don't know if I even knew what OSHA was in law school, to be honest. I mean, I might have been able to spell it on a good day, but I didn't know anything about OSHA. I actually, kind of just figure it out. Some people go to law school, their parents are patent attorneys. It's like, guess what? They're going to be a patent attorney. I mean, it's like very clear. I went to law school. No one in my family had any legal background. I started out as a criminal court clerk. So I was like a law clerk for 2 criminal judges in Essex County, New Jersey. After that, I started doing civil litigation. Like I said, all these construction cases. And amazingly, at my prior firm, I'd really been looking for a niche practice. Like, I want to be a subject matter expert. I get it. Someone's walking down the street. They slipped and fell. Now we have a lawsuit. I want something a little more substantive and with a little bit more variation to it. And the managing partner in our office came down and he said, Mike, you're doing construction. We don't have anyone who does OSHA. Why don't you do that? And, it seemed like a simple enough remark, but I'm like, okay, I got excited. We don't have anyone in the firm doing OSHA. So started writing some articles. I mean, if anyone wants to talk about establishing a niche practice, email me because I started not knowing a single thing about OSHA except just look on the OSHA website and, built it from there. It's like one of those things where you try a lot of things and they seem okay, but you're unwilling to commit. When I did OSHA, I just found it interesting. I liked working with companies. I thought it was really important. It was important to me. I know it was important to our clients. And I like that fact you can actually become a subject matter expert in certain areas. I mean, I'm not truly a subject matter expert, but I know more than the average person in certain areas. So it's exciting. And that was it. Just snowballed after that first harmless comment from the partner in our office.
So I think Michael knows more about OSHA than OSHA knows about OSHA. And I have seen I have seen the results from Michael Rubin, and he is the best out there on taking on these OSHA classes. And Michael, I want to ask you about what Ogletree Deacons do. You put on a workplace safety symposium. Now, I didn't attend the one in Florida, but this is going to be cool. Can you talk a little bit about this 3-day seminar that you guys put on?
Well, first off, I want to say I appreciate the comment saying, you're the best. I just want to let you know we have, I would say, the best OSHA defense practice group in the entire country. I look to my colleagues and I'm truly impressed. Okay. We have people just like me with incredible experience across the entire country. I would say 30 to 50 attorneys handling workplace safety matters. I would say 20 to 30, maybe that's their entire practice. So, I don't know where everyone is listening, but when I went to Ogletree, I felt like I got traded to the Yankees. Obviously, I'm a Yankees fan with apologies to none. But I like the Yankees. I grew up in New Jersey, went to the games, saw that game Derek Jeter dove into the stands and got like the bloody face against the Red Sox. I mean, I lived these memories. But the point is, not to get too far afield, Ogletree has incredible resources, and that's why I wanted to work at the firm. I love my colleagues. They're all really excellent. And every year, sort of to give some proof to this, every year in a different part of the country, we have a 3-day workplace safety symposium. I'm just one of many other speakers. I think 2 years ago, there were 30 of our attorneys speaking on OSHA, just to show the breadth of experience we have. Our Cal OSHA team, we have it's not like there's just one person manning the fort in California. We have a team of attorneys in California. I mean, they are incredible. But we have this every year. This past year, it was in the Tampa area. Next year will be in Austin. It's great. And it just brings everyone together. The last day, Melissa Bailey, who's one of our iconic figures in the firm, she goes through a fact pattern, gets the audience involved. Like, you literally can't hide. I mean, you have to participate. You have to listen, because she'll walk around and call on you. But it's just a great collaborative way to address all the issues that everyone learns and goes over those 3 days.
We had 2 clients attend the one in Florida, came away very impressed. So I'd recommend that. We always kind of end it, Michael, on a little bit of personal note. What does Michael Rubin do when you're not flying around the country, taking care of your kids and fighting OSHA cases?
So you're making an assumption there, Ron, that there is time other than taking care of the kids. Okay, just want to let you know it might be a faulty assumption. A lot of time with my wife and kids. We're just, might see me on LinkedIn and flying around and all these things, but we have a tight family. We are just going to hockey games, typical family, doing those types of things. I do go running sometimes. I mean, it's a on again, off again, love-hate relationship with lacing up the shoes. Some days you feel great. Some days you think, I'm getting too old, I need help. But just to be outside and living in Arizona, I mean, I've got a national practice, but Arizona is amazing for hiking, and we do family hikes and things like that. Just to kind of get off the grid is really very good thing for your health, to have some downtime.
Well, I think the weather in Scottsdale is pretty close to Newark, New Jersey. So I'm assuming you like the weather a little bit better.
Yeah, the weather here is great. If anyone's thinking, well, that's not fair, wow, there's such great weather out there. We were in Syracuse and Buffalo for a combined 11 years. So, I mean, we paid our dues. When you're in Buffalo, I mean, there's about 3 months of amazing weather, and you say, we have so much. I mean, you just can't get over it. But then once it's snowing in October or November, you think, how are we going to get out of here? I mean, what's our exit plan? The people are amazing in that area, but we like it in Arizona. I mean, it's hard not to like.
We're going to hope that Giancarlo Stanton has come back here. Gene, tell us about what you do, man.
Well, I've got the kids and the family too, and talking about hiking in Arizona, when we were there last, the family, we took them to Sedona, and we did a bunch of hikes up there, and it was awesome. It was absolutely awesome. Not too far away from Phoenix, but we enjoyed that a lot, and then went to the SCNRA conference, later that week. That would have been last spring. So you're in a little bit of a mecca there to get outside and see that stuff. It's super cool. Certainly different than Dallas, where we are. Shoot me. You see the freeways every day, but you don't get to see the natural beauty.
Well, I'll take a screenshot of the inside my car in July or August when it says 122. Right. I might even take video. I mean, the video might even capture how hot it is. I mean, it gets so hot. It's almost uninhabitable some days. It's so hot out. So it's not a free ride. I mean, there's not always easy here.
Well, It's dry heat. And I go, well, dry heat at 125 degrees is still 125 degrees.
Yeah, it's still pretty toasty. Yeah, 100.
Yeah.
And you get those dust storms in there too, don't you?
Yeah, since we've been here about 3 years. Not a ton, but yeah, I mean, those dust storms is just something they don't tell you until you move here. And all of a sudden it's like, by the way, we have this stuff coming in, and then you start doing some YouTube views and looking on YouTube of these past storms and things. But it hasn't been too much. It hasn't been too bad.
Well, I want to end it. I always end it with a little bit of a movie critique. And this is 1975. See, Hollywood's going through a really transition with all the streaming. So the big studios are suffering. But 1975 was a breakout year. And they broke out that year with a movie called Jaws. And that's the biggest advertising campaign they did for a movie at that time. It opened in 900 theaters. It became a blockbuster. But One Flew Over the Cuckoo's Nest won Best Picture, Best Actor, Best Screenplay, and Best Director. So 1975 was the turning point for big cinema breakout films. And so that's my comment on movies in 1975. Michael, I know you're a busy guy. I appreciate this hour of time with you. And any closing comments, we'll leave the floor to you, but I really appreciate you spending time with us today.
Yes, very much.
No, I'll just say thanks for this time. Obviously I'm passionate about OSHA. I was happy I could call out my colleagues who are really incredible to work with. And Ron and Gene, I mean, having partners like you in the industry, just great at what you do, but good people. I know sometimes people throw that around loosely. Oh, even better people. But just the events we've been at, I mean, I think the world of you both. And, right back at you, the respect I have for you both is really huge. So really appreciate this.
I appreciate that, Michael. And I have your recent P.O. box, so check us in the mail.
It's Zelle, actually, but it's fine.
Well, Michael, real quick, where can people find you if they're wanting to connect or follow you?
I'm on LinkedIn, Michael Rubin, OSHA. I'll probably come up, Ogletree. And then, they can email me. I guess this is your invitation for a plug or whatever, but it's michael.rubin@ogletree.com. And my cell number is on LinkedIn. I mean, we are immediate response. So one of the easiest things is to get in touch with me. So thank you, though.
Awesome, buddy. We'll have a cup of tea together.
I'm going to have some movie questions for you, actually. I didn't know this side of you, so now I'm going to have a lot of movie questions. I want to know 80, 85, 90, 95. I mean, I'm going to test your knowledge.
I have no life. So, hey, I appreciate that. Good, man. We'll see you in April.
Great. Thanks, guys. Thank you, Isaac.
Thank you.
Take care.
And thank you to our audience for listening. And be sure that you subscribe and leave the show a 5-star review. If you have any questions, you can reach out to us using the links down in the show notes below. And with that, we will see you next time.